And I'll be with you for the next hour. As our regular viewers are aware, on Just Law we discuss matters relating to English law. Matters that we discuss range from immigration law, family matters, criminal matters, personal injury matters, etc. Basically, any issues that you have, any questions that you have on any aspect of English law, you can raise that during our 1 hour show, and I will try and address your queries live on air. So as I've said, it's a live show. The number that you can call on should be appearing at the bottom of your screen. So please, whatever questions you've got, do pick up your phone and ask us any questions that you have. Just a couple of observations before we get going. And this is something we always say at the outset. Obviously, it's a live show. There's only limited information that we can take off you. Despite that, we will try and give you the best advice possible. But there are circumstances where we do need to look at, for example, your papers or to take more detailed instructions from you. If that's the case, we will advise you to leave your number with the control room and I will call you back and we can have that more detailed discussion off air later on. Now, the matters that we discuss not necessarily is related to the topic that we are going to be discussing today. You can ask any questions that you have on any aspect of English law. What I want to discuss today is a topic we've covered on many shows before, but it helps because there have been changes that have been coming in to take applicants through how spouse applications are made from abroad. But before I do that, I want to just update our viewers on a couple of developments which have occurred over the last couple of months. First of all, many of our viewers are very interested in relation to what's happening with spouse applications which have been made from abroad and whether there have been any changes in relation to that. There are a lot of rumours going around that things have been made more difficult, etc. I'm glad to say that at the moment nothing like that has happened. One of the Conservative manifesto pledges was to increase the financial requirement, which is currently 18,600. This is the requirement that an applicant from abroad has to meet if they want to come to the United Kingdom. Typically it requires the sponsor to be earning £18,600 in income. Well, that requirement, as far as the Conservative manifesto was concerned, was going to be increased from 18,600 to a much higher figure, probably in the region of 22,000. Luckily, it looks like that's not going to be implemented now. Although the Conservatives won the election, it doesn't look like that's going to be implemented. One of the other updates, again related to spouse applications, is that currently, if an application has been submitted and it falls for refusal because the income requirement hasn't been met, or because the type of documents that need to be submitted with an application, the documents haven't been submitted, so maybe it's to do with the actual requirement that isn't met, or maybe it relates to the evidential requirements in terms of documents that need to be submitted. Maybe that's not been met. Whichever it is, currently the position that the Home Office is taking is not to refuse those applications. All those applications are currently being put on hold. It does unfortunately mean that there are people who have been waiting 4 or 5 months for a decision. The reason that these cases have been put on hold is that the Home Office is in the process of revising the rules slightly. There may be some flexibility in terms of how the requirements are met. So at the moment, until the rules have been revised, until the new guidance has been issued, what the Home Office is doing is that if a case falls for refusal simply on the income grounds, they're not refusing the applications at the moment. They're putting the applications on hold until the new rules are brought in. The cases will be assessed against the new rules and then a decision made at that stage. All well and good. Effectively, it gives applicants a second bite of the cherry. It means if they don't satisfy the requirements now, there's a possibility that they will be able to satisfy the requirements under the slightly revised, slightly more flexible rules which the government is going to now introduce. However, the downside is that we don't know when the new rules are going to be introduced. So effectively, these cases which are on hold could be on hold for a number of more months. So it could be that somebody who's waiting currently for 4 or 5 months for a decision could find that they are waiting 6-7 months for a decision. So the difficulty is cases are on hold, they're not even being refused, so it's difficult for applicants to make another application in those circumstances, because the passport of the applicant has been submitted with the application. So it's not possible even to make a further application at this stage. Now, some of our clients who are quite concerned about the delay and having discussed this with them, are of the view that, look, if there's a problem and we can see where the problem potentially lies, what we can do is say to the Home Office, like, we wish to withdraw our application. We know you're not going to make a decision on it. We know that the case is on hold. It may take a number of months for a decision to be made, but we want the application to be withdrawn. I'll look at that in greater detail after I've taken the first call. Hello, assalamu alaikum.
Hello.
Ji, walaikum salam. Ji, jazakallah. Thank you for your call. What's your question?
Yeah, I came back to England with my wife under surrender sign.
Okay.
I'm a British citizen.
I understand. Yep.
Yeah, and she was about to renew passport now. She's going for the 10 years indefinite.
Yeah.
I was told that I have to work, and when we were coming, we weren't told that as a returning citizen, I'm to work.
Yeah. So you're the British citizen,
Yes.
and your wife, I'm assuming, has been granted a 5-year visa, a 5-year residence card already.
Yes.
Now I understand your question. The problem is, previously the law was that the British citizen didn't have to work. All the British citizen and the spouse had to do was to live in the United Kingdom. There was absolutely no requirement for the British citizen to work. Unfortunately, in around November 2016, the European regulations were amended so that there was a requirement for the British citizen to be working either in employment or to be in self-employment, or like the way other European applications are made, you could be a student or you could fall within the self-sufficient category. But what the Home Office required, even of British citizens who'd come back and their spouses had come back under the Surinder Singh route, what was required of the British citizen to be effectively doing what a European applicant would be doing in order to retain the right to continue living in the United Kingdom. So the British citizens are now required in this particular situation either to be in employment, to be self-employed, to be students, or to be self-sufficient. So it has actually been, it is something that has changed. Now, what you do need to make sure is either you, as the British citizen, you are employed, or if for some reason that's not possible, and it is your spouse, the non-British citizen, it's your spouse who's going to be in employment, and that is acceptable as well. That is acceptable as long as you have sickness insurance, which doesn't have to cover you, but it has to cover your spouse. So essentially, you as the British citizen, you need to work. If you're not going to work and your spouse is going to work, that is fine. You come within the self-sufficient category. But in that situation, she or he, whoever your spouse is, needs comprehensive sickness insurance. So it's very odd, but that's the way that the Home Office has changed the rules. Hope that's useful. Take our next call. Hello, assalamu alaikum.
Walaikum salam, brother.
Ji.
I just wanted to know if a person has been married here,
Yep.
And they have children, and they owe a lot of child support to the first wife's children, then, you know, will they have a problem with getting their spouse over? Because, you know, that if he's not paying for his children, then you know, he's willing to get the other lady over. That's unfair.
It does, absolutely. It does sound unfair. Not supported the first family, and then this is somebody who will be calling somebody else, and obviously there'll be a family that flows from that.
Yeah, I'm just saying that, you know, hopefully, because they owe child support, you know, will he not be able to get her over?
I understand.
He's got a child with her as well.
I understand where you're coming from. Unfortunately, to be quite honest, the rules don't cover that situation. The rules don't ask what the sponsor in the United Kingdom has in terms of debts or liabilities. The rules don't look at that at all. The rules, to some extent, take a very simplistic approach. All they do is they look at whether the financial requirements as set out in the rules have been satisfied or not. So in most cases, all that the Home Office is looking at is, does this person earn 18,600, whether as an employee or whether as a self-employed person? Or if they're exempt from that requirement, do they meet the rules which apply to those who are exempt? The rules don't look at, and neither do the questions that need to be answered as part of the online application or paper application which is made to get the spouse over to the UK. None of the questions actually talk about the sponsor's liabilities, such as any debts which are outstanding, any fines which may be outstanding, whether they're bankrupt or not, whether they've run a company which has been placed into liquidation. It looks at none of that.
But that is very unfair.
Yeah,
if he owes money to the first family and then he's not paying that,
and
then he's willing to bring somebody else over, that is very unfair. They should, you know, if he can't pay for the first children, why should he be bringing another woman over and another child over?
I completely hear where you're coming from, and what you say makes a lot of sense. But for whatever reason, the Home Office just hasn't gone down that route at all. Now, contrast that with somebody who's in the UK who themselves, not the British citizen, the person who's applying for a visa, if they've got an NHS debt because they've used the National Health Service, or they've got a debt that they owe to the Home Office lawyers because they've unsuccessfully pursued a claim which has been refused, and there's a cost order that needs to be paid. If the sponsor, not the sponsor, if the applicant himself or herself owes certain debts, the rules have been changed to prevent visas being granted where the applicant himself or herself owes certain amounts of money. But here the problem is we're looking at the sponsor, and the sponsor's financial circumstances as far as debts are concerned aren't taken into account at all. We'll take our next call. Hello, that call might have been dropped. I think there's somebody there. Hello, assalamu alaikum.
Wa alaikum salam. I've got a question to ask.
Yeah, sure. If you fire away, yeah, I'll try and help you as much as I can. Yep.
I've got my brother in Zambia. He's been very not well for a long time.
Okay.
And I live in UK for a long time. I want to sponsor him. What do I have to do? Okay.
Do you want to sponsor him on a temporary basis or on a long-term basis?
Long-term.
On a long-term basis. Now, on a long-term basis, I know you say your brother is unwell, so there is a possibility of coming within the immigration rules which cover adult dependent relatives. So essentially there's a specific category. Even if you go onto the Home Office website and you look at the rules for adult dependent relatives, there's a specific category which covers that situation. The only problem is, although that category does exist, the conditions which need to be satisfied are quite onerous. So the starting point normally is that the person abroad would normally need personal care. So it's not sufficient that they're unwell.
His mentally capacity is not very good.
No, that may come within the definition. So personal care is, they would need assistance with clothing themselves, going to the loo, having a shower, going outside, having food, etc. So if that's the level of care that's required, that's the first condition which is satisfied, which is normally the most problematic, because somebody might be unwell but not unwell to that extent where they need personal care. But let's assume the first condition is satisfied, that their illness is such or their disability is such that they do need personal care. The second requirement, which sometimes it's difficult to satisfy, is that there should be nobody in that home country able to provide that personal care. So nobody from one's family, or if you look at professional care provided, it's not even possible to get professional care from somebody. Now, that in terms of professional care, that varies from country to country. For example, if you take the United Kingdom as an example, we have a system here where the local authority will provide personal care, or there are loads of private companies that provide personal care. So if an applicant actually lives in a country where that system of professional personal care is available, then it becomes difficult to satisfy the requirements, because although the person may need care on the one hand, the problem that arises is that that care might be available either from family.
Yeah, but financially, I have to support him.
Yeah. So
when he lives in Zambia, he lives place to place. The check keep changing. My other brothers, they don't look after him.
Yeah. So
then he say, like, why I'm letting? He's my own brother, and why should I let him suffer when I'm the elder sister here?
I completely understand, and to be quite honest, the rules. Most people are unhappy with the rules. The rules have been challenged in the High Court as well, because they are very, very restrictive. But unfortunately, the courts have said they may be restrictive, but they're not so restrictive as to be unlawful. Because one of the things that they look at is whether the law that's been introduced, whether it complies with human rights obligations that the government has to fulfill. And when these cases have been challenged, unfortunately, the judges have come down in the favour of the government and said the rules are human rights compliant. That is the problem that we have, because there are a whole host of problems. Personal care, is personal care available in the home country? Can you afford to provide that personal care? Then we go on to the hurdle of, if you was to come here, would you be able to look after the person financially? I think that's normally the least of our problems. Most people are hopefully able to provide for their family financially because they're in employment, or they've got partners who are in employment, accommodations available as well. The problem arises is that they will normally say, well, we don't think, first of all, that that level of personal care is required, and secondly, even if it is required, there's family there that can provide it. Who's there, who's providing the care at the moment? Why can't that continue? And leaving family to one side, they will then say, well, you know, if it's not family, there is professional care available. And look at the particular country you're talking about. These are the companies that provide care, and it's affordable care. You can, if you're going to spend money on somebody coming here, you're going to spend a couple of £100 looking after them a month. That is money that you could spend on their care in their home country. I don't want to discourage you from making the application, but it's one of the most restrictive categories that exists in the immigration rules at the moment. So the category does exist. You just need to take a view on whether you can get the evidence together to make that application. Just on a final point on that before I move on, which is that there is, in order to qualify, for the applicant to qualify under the adult dependent relative category, there is a need to produce good, solid documentary evidence, in particular medical evidence. So we would need to submit, or you would need to submit, a letter from a senior doctor confirming the applicant's illness, what kind of care is required. You'd also need to submit evidence from local authority, etc., confirming that that level of care is not available. So there's a need for good, solid evidence to succeed under that category. Okay, we'll take our next call. Hello, assalamu alaikum.
Hello, assalamu alaikum. Yeah,
Wa alaikum salam.
I need to speak with a lawyer.
Yeah, you're live on air, brother. So if you tell me what your question is, we'll try and go through it.
Okay.
Okay, fire away then. Yep. Brother, you're live on air. If you
Hello,
want to.
Assalamu alaikum.
Walaikum salam. Ji bhai.
Basically, I just need to ask my wife. She's on spouse's visa.
Okay.
And she's got second time granted.
Okay.
Like twice. She's on a 5 years route.
So this is her second grant of
she's a second grant.
I understand.
She's on.
Okay.
My question is this: basically, we show 18,600 twice.
Okay.
My salary.
Oh, I understand. Yep.
Yeah, and now we're going to apply for the ILR indefinite stamp.
I understand. Yep.
Yeah,
Yes.
and do we still have to show 18,600?
Yes. In short, the way it works is that even at the indefinite stage, you still have to demonstrate that between you, you have an income of £18,600 as well. The only difference with the settlement application is really as far as the English level is concerned.
Yeah, English level is been passed. Yeah, she's done that English level. We show the English. She's done the master's degree.
Oh, fantastic,
So,
fantastic.
Yeah, she's been exempt from English language.
I understand. So the only other difference is that she will need to do the life in the UK test.
Life in the UK, yes, she has to do, yeah.
But brother, in terms of your question, your specific question, the position is that the financial requirement has to be met at the end as well. So
has to be net 18,600 to show on the indefinite as well.
Yes. So like you've done before, where 6 months before you've got your wage slips ready, you will have to do, or if you're self-employed, you've got your self-employed.
So is it, yes, I'm a self-employed basically. Yeah. So it has to be 6 months or 1 year.
No, with self-employed. Are you operating a limited company, or are you self-employed just operating as a sole?
No, I'm operating a limited company.
All right, okay. So with a limited company, the requirement is that you need, in terms of, first of all, what you do is you look at the time period. For a limited company, it's the limited company's financial year. So you look at the last financial year that's passed before the settlement application is made. So for example, if, let me just ask you specifically, when does your wife's visa finish?
It's in August 2018, and I am basically my accountant. He's preparing that last year accounts.
Okay, so the financial year for your company, what is that? Do you
my financial is normally end of August and November, but he changed to now end of January.
January, okay. So for you, the financial year will be January 2017 to
so this year basically.
This year to the 31st of December 2017 as well. So you're looking at, first of all, your income in that period. So it's so whatever salary you've got from the company, whatever dividends you've got.
For the company is basically 40 plus
right,
it comes. But accountant shows normally less. But last year, because my wife, she extended visa.
Yes.
So last year we shows like a 21,000 salary.
Okay, all right.
But he normally shows basic salaries like like NI below threshold,
which
basically.
is fine. But I mean, what you can do, if you do want to keep it below the threshold, you can do that. But you need to make it up with the dividends. So I mean, obviously your accountant knows better in terms of what to do.
Yes, he shows that 10,000 dividend last year.
Fantastic.
So basically, if I speak with my accountant this year, he can keep that salary threshold, but he has to give the dividend like roughly about 20,000 or 15,000 to me. Yeah.
Yeah, or you could be your salary could be £10,000 in 2017, and then your dividends could be £10,000 as well. So combined, it comes up to £20,000. You could give some dividends to your wife as well if it's more tax efficient. There's no.
No, she's an employee of that company.
Yeah, she's an employee, so she obviously gets
She's getting
a
like
wage as well.
£6,000 per year.
Fantastic. So you can use that. You can use your salary. You can use your dividends as well to meet the requirement.
Okay, I was just confused about my year, which you just clarified that January 2017.
The starting point always is when somebody is self-employed, operating a limited company, is look at the period first, then look at income and the evidence. So the period for somebody who operates a limited company is the financial year of the company. So it's the last financial year, if your wife's visa finishes in August 18, is, as you said, 1st of January 17 to 31st of December 17. So inshallah that should be okay. Can't see any problems with that.
Okay.
Okay, brilliant.
Yeah, and okay, thanks very much. Thank you.
No problem at all. Thank you for calling.
Thank you. Bye-bye.
Thank you. Right. We'll take our next call. Hello, assalamu alaikum.
Walaikum salam. Will you be able to help me? I want the employment tribunal solicitor, please.
Yeah, it depends what kind of case you have.
It was employment tribunal because I was working for 11 years.
Okay, all right. Okay.
And they suspend me for that. I tried to get the lawyers.
Okay.
But they're just taking money from me.
Okay. Have you been dismissed? Are you suspended at the moment? If you just
suspended.
Suspended at the moment. Have you got a disciplinary hearing to attend at any stage? Or?
The hearing is gone, but I need to find out what grounds I've got to find out.
So have they dismissed you already, or they haven't dismissed you? What's the position at the moment?
They're going to dismiss me.
They're going to dismiss you. All right, okay. Well, look, if you leave your number with the control room, you may not be able to leave your number now because we've got a number of calls coming in. It may be that you need to call around 7 o'clock.
Can I give it to you, please?
You can do if you want your number to be broadcasted live on air, or if you want to wait till 7 o'clock and you can give your number then. It's
okay.
It's up to you. That might be better. Otherwise, I'm not sure. I'd want my in the control room. They'll take your number. If you stay online, they'll take your number, and I will give you a call back and have a more detailed discussion with you. Thank you very much for your call. We'll take our next call. Hello, assalamu alaikum.
Assalamu alaikum.
Walaikum salam. Ji bhai, thank you for calling. What's your question?
Okay.
Ji? Bangladeshi, brother, I would struggle with that.
Okay.
Urdu, English, or Gujarati even. But, brother, I would struggle with that. Ji bhai.
My question is, I'm going to apply for the extension of my spouse visa, past extension.
Okay.
So the problem is, do I need to I live in with my wife in housing association house in a house with the rented. So if the company give us letter state that two bedroom house living two people, is that sufficient enough, or we need any extra document for this?
Do you your visa at the moment? Do you have a spouse visa at the moment?
Yeah.
The 2.5-year spouse visa.
Yeah.
At the moment. So, and you just wanted it extended. Are you on the 5-year route, or are you on the 10-year route?
Yeah, I'm 5-year route.
5-year route. Look.
Some people say that we need an inspection report or something.
On the 5-year route, when you're applying for the extension, to be quite honest, they are not too strict with the accommodation requirement. You certainly don't need a property inspection report. You don't need that at all. Normally, you mentioned, shall I get a letter from the housing association confirming? If you want to, you can get it. You don't need to. Who is the tenant for that property? Is it
my wife? My
your
wife.
All you really need to do is, you don't even need a letter from the housing association. What you need to do is put the tenancy agreement in.
Okay. Yeah, we have got this. Yeah.
I would say in 99% of cases, the tenancy agreement in itself is sufficient. You don't need a letter. You don't need a property inspection report. That is for a spouse application which is being extended, which is what is the situation with you. Just for the benefit of our viewers who are listening to this, the position is different when you are making the first spouse application. If you're so the people don't get confused. For example, if somebody from here is calling their husband or wife over from abroad, India, Pakistan, Bangladesh, then they would need everything. They would need the tenancy agreement, the letter from the housing association, and a property inspection report. But in your situation, when you're applying for an extension, just the tenancy agreement in itself is enough.
Okay, thank you very much.
Okay, thank you very much for your call.
Thank you.
Thank you. Right, just then going back to the updates that we were doing just before we took our calls. The main update that I was dealing with was the substantial delay, but just before I go on to that, let me take the next call that's waiting. Hello, assalamu alaikum.
Walaikum salam. Hello, dear. I would like to on my case.
Okay.
I came as a student in 2010.
Right, okay.
And then I've got post-divorce visa in 2012 to 2014.
I understand.
And then I've made application Tier 1 business visa.
Yep.
Unfortunately, this application is not been successful.
Okay.
And the outcome I've got in 2016 June.
Yep. Okay.
And in 28 days, I've made applications on the basis of my partner, FLRFP.
I understand. Yep.
And still I'm waiting for the outcome, sir. They took a fee in June. Then I've applied in 2016. The Home Office took a fee in £811.
Right.
And after 1 year, I had a newborn baby, and I sent to the Home Office his British passport and the birth certificate as well. And the Home Office took a fee now again £811.
Why did you pay a second fee? Sorry.
Yeah. I've already spoke to my lawyer. The lawyer sent to the letter to the Home Office, but they didn't reply. I've already met with the local MP. The MP sent a letter to the Home Office today as well.
Sorry,
See, my lawyer emailed me today, and he got a biometrics letter again from the Home Office. And he said, I've got a biometrics letter again from the Home Office. Can you come to the office and pick up the letter?
Okay, brother, let me just stop you there. Right.
So the Home Office can take send me a letter again for the biometrics on the one application.
Right. Your first application, FLRFP, submitted in June 2016, right? Which was outstanding for a year. Yep.
Yes.
Why did you submit another application?
No, we didn't submit the other application. Just we updated to the Home Office.
So why did
about my newborn baby boy, his British passport and his birth certificate.
Okay, brother, but why did you pay a fee then?
They took because they go on my detail, the bank details from the last application on the form, and they took the fees from the same account.
That's not right. That's not right. Brother, it doesn't work like that. They would only take a fee second time round if you submitted an application form with your details. But there was no need to submit an application form, because all you had to do, or all your lawyer had to do, and I don't know what your lawyer's done, I'm not criticizing your lawyer, but all that was required was just a letter with a birth certificate saying, look, I've been waiting for a year, and by the way, we now have a baby. So if that was done...
sorry,
Jibay, go on. So,
just my lawyer sent my newborn baby's birth certificate and his British passport, and just send a covering letter. She didn't send any new application to the Home Office.
It doesn't really make any sense. Right, okay, hold on. Let me go back. June 2016, when the application was submitted, did the Home Office take the fees at that stage or not?
Yes, when I made application in 2016 June, I've made application 28th of June. They took a fee 30th of June after 2 days.
Right, okay. Assuming what your understanding is correct, that shouldn't have happened. The fee can only be taken once. When the application is submitted, you should get a refund of that fee. Definitely you should get a refund of that fee. There's no basis for a second fee to be taken. So I think what you've done is right. Get your MP caseworker at your MP's office, get that person involved, get them to write in and find out what's going on. On the second point, which is about the delay, there is a significant delay at the moment with FLRFP applications. To be quite honest, I mean, my cases, some of them are up to 10 months at the moment, in terms of 10 months in processing, or 10 months waiting for a decision to be made. And that's the amount of time it's taken at the moment, around 10 months. So it's not odd that your case after 12 months is outstanding. But what I would do is, okay, you're sorting the fee, the second fee that's been taken, you're sorting that out. At the moment, push to get a decision on your old June 2016 application as well. Push for them to make a decision on that. Hopefully, with the circumstances that you've described, where you've had a baby, assuming wife is British, wife is, inshallah, shouldn't be a problem. You will get your visa. I cannot see a problem. Wife is British. Obviously, the child is then automatically British, because the child has been born here to a British wife. I cannot see a problem in your application being approved. So if you've got the MP's office involved, get them to push the Home Office now to make a decision. By all means, get your second application fee of £933 or whatever it is that £993 or whatever it is that you paid, get that money back as well. There should be no reason to submit a second fee, but at the same time push them to make a decision as well, because 1 year to make a decision is a long time, bearing in mind the kind of money people are paying for these applications. So hope that answers your question. And it just so happens that in terms of the updates that I was doing, one of the things that I wanted to bring to the attention of our viewers, which our brother's question has actually brought out, is the significant delay in what we call human rights applications in having those processed. It is now not uncommon for these applications to take 10 months, 11 months, as the brother was saying, 12 months for an application to be processed. And unfortunately, that does mean that lawyers who have submitted these applications, you've got clients who are ringing lawyers, saying, lawyers, what's going on? Nothing's getting sorted out. You know, it's ridiculous. And we agree it's ridiculous, but to some extent, our hands are tied. What I'm saying to clients is get in touch with your MP's office, get them to put some pressure on to sort this mess out. That takes us to our break. Inshallah, we'll be back in the next few minutes and we'll take our discussion further then. Thank you.